Good morning. Thanks for your patience. The other computer I tried to sign on to is still cycling for some reason. So we're just going to leave that to the tech people, figure it out later. All right. So this is one of my recusal cases. And we are here in the Fayette County court for Martini and versus Red Room. So who's representing whom? I got that right?
That's right. Good morning, Your Honor. Thank you for hearing this case. My name is Mike Kaplan with Kaplan Cooper, and we represent the plaintiff petitioner, Martinis Inc.
Okay, Mr. Kaplan, good to meet you. All right, and who's here on behalf of Red Room?
That's Daniel.
I only represent Mr. Gagarin.
Correct.
All right, so Red Room is an incorporated entity by rights, should have its own attorney. Is there no attorney for the incorporation?
So Your Honor, we did not serve Red Room.
Okay.
We're looking to revive this as to the individuals.
Okay.
And so Mr. Stooksbury was here. I don't know if he's still on with us.
I'm back on.
Okay.
So, Mr. Stooksbury, I know I was the cause of the technical glitch, but are you able to allow us to see you?
Well, I had this actually, you were not the cause of the glitch that I had. My internet went down, which is
Okay.
pretty common. So I'm on my phone.
Okay.
This is new to me.
No problem.
I'm not real. Let's see here if I can figure this out.
Do you have an iPhone? So I don't have an iPhone. I'm Android, but my understanding is there may be an icon.
How about that?
Actually, yeah, we just see iPhone.
Oh,
it's okay. Don't stress.
I'm sorry. I don't really know what to.
Miss Powell, do you have an iPhone?
Judge, if you have an iPhone, there should be an icon that says camera at the bottom of your screen where you see the other icons, the chat icon, or say video actually, near the audio icon. Okay. And right now you might see that it has a red slash through it. And once you click that, your video should turn on. Once you click that icon.
My secondary tech is always find a young person.
Well, that's the way it has to be for me too. And I don't.
All right. Well, if y'all are willing to waive his appearance, not his presence, I'm fine with going forward until he figures it out.
Yeah, I'm working on it. So you go ahead. I want to know. I mean, I just have a lot of questions about why this is being renewed after so long of no action whatsoever. And secondly, who am I being sued by? Because there is no Martinis, and there hasn't been since 2012 was the last filing. No, excuse me, 2011.
Well, Mr. Stooksbury, we are going to get all of those questions answered. Mr. Kaplan, do you want to go ahead and give us the why we're here and the how this all started kind of thing, thumbnail?
Yeah, Your Honor, this is the petition for scary facias or a motion to revive a dormant judgment under OCGA 9-12-61 at SEC. And a judgment was obtained following a motion for summary judgment that was granted back in October of 2012. As you know, after 7 years from the time that the FIFA is recorded, which was in 2013, that the judgment goes dormant. That did not bode well for Martinis Inc. and its principal, Mr. Adducci, who is present, because with it going dormant, I believe it was Mr. Stooksbury that was able to sell his home and not pay off the lien. Mr. Stooksbury is now, I think, in Costa Rica. We then moved for a motion to revive the judgment within the 10-year period. As you can see, it was on March 11th, 2022. That's when the judge over in Fayette County, Judge Thompson, recused himself, and then we were on a 2-year odyssey to have a judge hear it, and we're thankful we're here today with you. We have served Mr. Stooksbury by publication in accordance with the statute because Mr. Stooksbury is outside of the country. And we have not sued, so I was actually very surprised to see Mr. Calamaro, who I don't believe we've had an entry of appearance from,
Yep.
or Mr. Gagarin, because we have made incredible efforts to serve Mr. Gagarin. Mr. Gagarin has a camera installed at his front porch and he won't come to the door. So we have not been able to serve him. So what we would have to do is either have another hearing and bring Mr. Gagarin back after we do get him served, because we won't stop until we do, or we can have Mr. Calamaro and Mr. Gagarin waive the service and consent to the jurisdiction and to be subject to this. Your Honor, it's very simple. There was jurisdiction before. Summary judgment was argued. Summary judgment was granted for the plaintiff. Martinis Inc. is an entity that is entitled to recover these funds, and the funds have not been paid. Mr. Aducci would testify to that, other than saying that nothing has been paid towards these judgments. We can't really prove a negative, so it would be up to Mr. Stooksbury and Mr. Gagarin if he consents to waiving service under the statute, to show us that they've paid this, because they haven't. And the fact that it has been going on for so long, and why we're still here to answer Mr. Stooksbury's question, is because they haven't paid on it.
What's the amount of the judgment?
So the judgment in 2012 was on two counts, and on promissory number one, I'm sorry, promissory note, principal amount at that time was $59,953.99, interest of $3,976.57, attorney's fees of $8,993.09, and of course, there's a FIFE fee of $9, and post-judgment interest runs, but we would, that would just be in accordance with the order, but it would not be in the FIFE.
Okay, and that was for the first promissory note, you said?
That's for the full judgment.
Okay.
There were two. I'm sorry.
Right.
So they're both included in the amounts that you gave me?
Correct.
Okay, just wanting to be clear. All right, what was the judgment based on? I mean, it was summary judgment, but what was the
Promissory note, Your Honor.
okay, was Martini's a loan business, or?
Martini's was a restaurant, and we owner financed a portion of the sale. The Red Room, Gagarin, and Stooksbury bought the restaurant that was operating and generating income. And I would like to double check those. The total amount, I thought that there was one judgment for $25,000. There were two parts to that, and one for $59,000. I don't, that to verify that that's the total. But
the total FIFE is $59,000. It's attached as an exhibit, Your Honor.
Mm-hmm. Okay. All right. Did you have anything else to present, Mr. Kaplan?
No, Your Honor. Again, it was one note for 34 and change, and one note for 25,000 even.
Okay.
That's what
Okay.
equals the 59.
So that's the 59.
Okay.
All
Yeah.
right. So Mr. Stooksbury, I think both our questions have been answered. So per the statute, it's proper after the 7 years, if the collection hasn't been completed, then they can bring up action to revive judgment, and they can revive it periodically per the statute. So that's why we're here. The underlying judgment was issued by the court, the judge who was previously on the court. So that money is still owed. The amount of money or the fact that it is owed does not get extinguished by time until the statute completely runs. And then it is my understanding that Mr. Gagarin and Mr. Stooksbury, you all were principals of the Red Room, and the individuals who in fact financed the purchase of the company or the restaurant through Martinis. And so that's why we're here. All right. Mr. Calamaro, are you wanting to speak on behalf of Mr. Gagarin? Since he hasn't been served, you have no obligation to.
Understood, Judge. No, I believe he received a copy in the mail, as I understand it. And in the absence of service, obviously he's not subject to anything. But in the interest of I guess taking a belt and suspenders approach, I recommended that we at least appear, and
in case I was some crazy judge who said, they're not here, I'm gonna do something.
Well, those are not the words that came out of my mouth, but yes,
That's
I mean,
okay.
just to avoid any potential
Well,
issue
just
there.
to perfect the record, you are not at this time going to waive service.
No.
Okay. All right. Oh, I lost Mr. Kaplan. 1 second.
Your Honor, I'm going to try to, this is Mike Stooksbury. I'm going to try to reboot my computer,
Okay.
which seems to be the problem. So,
Daniel?
Yes.
Mr. Kaplan, I'm here. We got you.
Your Honor? Oh.
Yeah. He has decided he is not going to waive service. So that was the last thing we talked about before you disappeared.
We're having a connection issue on my side.
That's okay.
Okay, so I'm sorry, from the second you turned it over to Mr. Calamaro, I was disconnected.
Okay, so here's and Mr. Calamaro can correct me. This is what I heard, that they were here out of an abundance of caution. Mr. Gagarin received notice in the mail, but was not in fact served. And as such, they are not willing to waive service, but they were here just in case I was a crazy judge. That was my part, not his.
Will Mr. Calamaro acknowledge service on behalf of Mr. Gagarin for the next hearing?
For the next hearing or service of the petition?
It all gets served at the same time once we get a new hearing date.
I don't have authority from the client to acknowledge service.
So, Mr. Stooksbury, another thing that you may be wondering that has probably not been made clear to you, but possibly has, is generally when there's a judgment given, there's joint and several liability for the judgment. Is that what's going on? So both of these gentlemen are liable for the entire amount. Whoever pays it, whoever y'all can get it from, or whoever Martinez can get it from, they're fine with that. So if you pay it all or some portion of it, then they're fine with that. If Mr. Gagarin pays it all or some portion, they just want it paid. So with that being said, both gentlemen owe the entire amount until it is paid.
That's correct. So today, I guess we'll have it revived and reinstated as to Mr. Stooksbury, and then we can continue.
I don't think we've gotten to that. yeah, I have a lot of questions. And actually, my question is to you. How did you perfect service on my 86-year-old mother? Because I have never in my life lived at my mother's house. So if you served me at my mother's house, then how did you even get that information that I live at my mother's house? I don't understand. How can somebody be served? In my opinion, I should be in the exact same spot as Mr. Gagrin. Every person in this, every person involved in Martini's Red Room knew that I lived in Costa Rica. I waited until this thing expired to sell my house that I had rented until after this expired. And that they had 7 years to clear that up. Secondly, my next question is, how in the world are you representing Martini's when Martini's literally abandoned the corporation in 2011 and was administratively dissolved December 31st of 2015? There is no Martini's, and there was no paperwork filed saying that Mr. Aducci was taking over all of the assets or potential assets of Martini's. So first off, I was not served. Secondly, there is no Martini's. And thirdly, Mr. Gagrin and I were not actually, we were owners of the Red Room, and we were guarantors on these loans. We were not the original loan, I guess you would say, Red Room, that the agreement was between Red Room and Martini's. Both of those entities are gone. We were guarantors on the loan, and the loan expired with absolutely nobody even attempting to collect on the debt. So this is the craziest part about it. 7 years went by. I owned a house for 4 of those years and a car in the state of Georgia. Now none of that is the case. And I think Mr. Kaplan probably received a letter from a law firm that represents me. I am on Social Security disability. I am protected by the American for Disabilities Act, and I have several other protections that absolutely, I believe if we went to court and I hired an attorney, or if I even did this on my own, took care of this on my own, that a jury would definitely find that Mr. Gagrin and I are not liable for this anymore. Whether Mr. Ducci thinks he is the person that should get this money, I don't believe he is. I believe it's Martini's Inc. And there is no Martini's Inc. Martini's Inc. is dead. It was forfeited. So that is my argument to this whole thing. And next to that, there is no way in the world that if I sit here and gave you my banking information, that Mr. Kaplan would be able to collect anyway, because it's Social Security disability. And I'm happy to share that information. And that letter that was sent to Mr. Kaplan probably 3 weeks ago explained that. Did you get that letter, Mr. Kaplan? Hello?
Your Honor, I'm not sure what I'm supposed to do here, but we're asking that the judgment be revived. Whether we can collect it or not is not relevant to this proceeding. So far, what we've learned from Mr. Stooksbury's comments is that he was well aware of the existence of the judgment, waited till it went dormant, and then sold his house. Good on him. But as he said, he did guarantee it. He was obligated on the note. And, whether the Secretary of State needs $14 to reinstate the corporation on its website or not is irrelevant to whether or not Martinez is allowed to revive this judgment.
I do not believe that is the case, ma'am. And I really, that's why we need, if you want to keep this up, then let's just take it to court. Because
We
I am
are in court.
Mr.
100%
Stewksbury,
willing.
this is court.
This is court.
Well, I
DeRoe,
understand,
see
ma'am, but we
DeRoe?
need a court by jury, and that is what we are guaranteed the right to, because
Well,
I need to.
you had that in the initial action. You had the opportunity to have a jury in the initial action. Unfortunately, because of the legal posture of the case, it was decided by summary judgment, which meant that the defense put up no evidence that would have been something that could have been considered by a jury.
Yes, ma'am.
The evidence that was presented on paper basically said that the judge made the decision to grant the judgment because there was no defense against the judgment being owed, number one. Number two, with you being the guarantor on a loan, it's just like when you go with somebody and they say, hey, can you co-sign me buying a car? Horror stories I've heard ad nauseum. Well, if they don't pay for that car note, then the person who co-signed is in fact the person that the company is going to come after, and the person in fact who owes the money. Now, it does not speak well of you that you basically have admitted to trying to avoid paying a judgment that you owed for a business deal, because what you're saying is, well, it was a business. Martinez is a business. It's not here anymore. So we're deciding not to pay them because there's no actual person. When Martinez didn't, Martinez may have been the business that collected the money, but some person, that money was owed to some individual. And so what you're saying is, well, I've gotten away scot-free. I managed to live the 7 years without them collecting. And now I'm an expat in Costa Rica and y'all can't get me. That doesn't mean they're not entitled to the judgment. It just means that you've, to this point, successfully avoided the obligation of paying the judgment.
Okay, one other
somewhat
aspect.
Dishonorable, actually.
Well, ma'am, it's not dishonorable, and let me explain why. I sold my share of the Red Room to Mr. Gagrin. And over the next year and a half, the Red Room business started going down and he was not able to make the payments. But he guaranteed that I would be exempt from this loan. So yes, I did not feel obligated to pay this loan. So I still haven't heard anything about how in the world service was perfected, because ma'am, if
Mr. Kaplan, you said you perfected service by publication. Is that correct?
That is correct. And we knew that
right.
he was in Costa Rica because he sent correspondence saying, I'm in Costa Rica. Here's how you can contact me. And
Right.
so we knew he was there. So I filed the statute because he was in Costa Rica. The court entered in order and he was served by publication. And, to add on to what you said, Your Honor, I mean, my client sold his business. They bought a business without paying for it. Whether it succeeded or failed after that is on them. Whether Mr. Gagrin said he was guaranteeing Mr. Stewksbury's payments is between them.
I'll only point out that I don't think Mr. Gagrin said that, at least not today.
Nope, he didn't say anything today.
That's correct.
I like to make a clear record. All right. So the service was an issue. I wrote down everything you said, Mr. Stewksbury. I don't want you to think that I'm taking this lightly. So every question that you had, I wrote, it's a bullet point on my list. So one, I have that you questioned service. Two, the fact that Martinez was administratively dissolved, and how does Mr. Aduche then become the person to whom the judgment is owed. Three, that was 2 and 3. 4, the fact is that you were a guarantor on the loan. We have addressed that.
Yes.
The court hasn't seen anything where Mr. Gagarin releases you from the obligation to the judgment that was entered by the court. So that might have been a side agreement between you and Mr. Gagarin, but the court and Martinez is not in privity of contract with you and Mr. Gagarin with respect to that release and the obligation of Mr. Gagarin to completely pay the entire judgment. So that's something between the two of you. That is something that you all will have to work out. As such, the court still believes that the judgment is owed jointly and severally by the two of you. And with you being an expat, it may not be a judgment that is collectible, but it doesn't mean that it can't be the judgment can't be revived. So those are two different things.
Ma'am, the only reason I am addressing this at all is because there are a lot of people going to jail that are in my situation for debts, whether they owe them or not. And the court's saying that we did not show up because we never received notification. And I am in a situation to where that is possible. The notice that came to me, I just received on Thursday. And that's been 2 months since it was sent to me, except for by email. But I don't want to be in a situation where I come back to the U.S. to visit my family and I've got some warrant out for my arrest because Mr. Kaplan filed a hearing and I knew nothing about it.
Well, I got that. The only way that would happen on a civil case is if you had failed to participate in post-judgment discovery and there had been a long period of your not participating after being served. However, in this case, I don't have the ability to do that because you're outside the country. You haven't been served with post-judgment discovery, and I cannot order you as a part of a discovery dispute to appear before the court and complete the discovery, which is the only way in a civil case that there may be some. So what, I don't. It's civil. It is not criminal. And I don't have that power to exercise against you. Essentially, what this is that it revives the judgment, meaning it tells the court tells everyone that this judgment is once again collectible, and you can use whatever efforts under Georgia law to collect the judgment. It doesn't mean that I get to put anybody in jail.
Okay, then in that case, we're just wasting the court's time, really. The problem that I have is if Mr. Kaplan says that he's going to serve my 86-year-old mother this paperwork for whatever he plans to do to try to figure out where all of my billions of dollars are, then, that's the problem that I have. I do not want to come home, visit my family, and have that hanging over my head. So you're telling me that is not possible, or that is not going to happen?
I'm telling you that I cannot jail you.
Right.
And there will be no warrant waiting for you when you come into the country because you have not been served discovery that you've not responded to. That is a process. Number one, that would be the only way that a warrant would be waiting for you. But the attempts to collect, I don't get involved in the attempts to collect on a judgment. Georgia law is very expressive on how you can collect on a judgment in the state of Georgia. Once the judgment is revived and a 5A has been issued, then there are steps that can be taken under statute to collect the judgment. So that's what that then again becomes between you and Mr. Kaplan, how he wants to collect, but has nothing to do with me. Aside from reviving the judgment and making the judgment once again legally viable.
Okay. Well, I'm sure Mr. Kaplan understands the certain things that need to be made clear in this situation, and he's already received. Mr. Kaplan, did you say that you have received the letter from Helps Law Firm?
I
Okay.
I'm not in my office in the moment. I don't know. Your Honor, I don't know what he's talking about, to be honest with you. I may have initially tried to serve him in the United States at a last known address. Once he gave word that he was in Costa Rica, we've proceeded in accordance with, that. I've been doing this a long time, Your Honor. If he doesn't like this hanging over his head, I'm happy to talk to him. Otherwise, I don't know what to say.
As long as I'm not gonna have a warrant hanging out over my head, it's not a, it's not a concern for me. This should have been taken care of when Mr. Ducci and I in 2017, when I made him an offer and he accepted, but he never showed up.
No, there was no acceptance of that offer.
You
Okay,
accepted it
guys,
verbally.
okay, whatever,
Ducci.
whatever negotiations went on have nothing to do with me.
Okay.
I am strictly here because there is a judgment. The time has run on that judgment. The law
Yeah.
allows the debtor to come and seek to have the judgment revived. That is all I'm doing. And
Okay.
so any negotiations that take place around how this can be paid or how it
Yeah.
should be paid or how it can be collected or should be collected, I'm not being insensitive, but I really don't care because those don't involve me.
Well, ma'am, you have the exact same stance on that as I do on this so-called debt.
I got you.
So,
But I mean, I spend a lot of my time teaching business people to think in ways that are to think, I guess, more like a lawyer.
yeah,
And in the sense, I think a lot of business people think of things in ways that aren't legal. And I don't mean illegal. I mean, they don't follow a legal course. And so if you have a business that buys another business and the money is owed, doesn't mean that just because the business goes away or you decide not to pay it or you wait it out, that the money won't be collectible at some point. And so
right.
just to assume, because I have a lot of people on my calendar who have credit card debt, and they
Yeah.
think that because that credit card debt expired or was 10 years ago or 15 years ago, and they weren't even the person who was, they're not even the same person anymore, as some people have said. They think that goes away, but it just really doesn't. And so you deal with it once it's revived, however y'all want to
Right.
deal with it, but it doesn't mean I cannot, under the statute, revive the judgment.
Right. And those very people that have that credit card debt that is outstanding are in a similar, some of them are in a similar position as I am, and they take the risk, from what I understand, of somebody saying that they served them, but they were never served. And then there is a warrant out for their arrest because they never addressed the court when they didn't know anything about it. That has happened quite a bit.
Okay.
Your
Hopefully
Honor,
That's
I
my only
haven't done
concern.
that. I got you, Mr. Stooksbury.
Okay.
Anyone else have anything else at this time?
yes, Your Honor, one more thing.
Mhm.
It is kind of a red letter day for me, as Mr. Gagarin and his attorney are both present. I was wondering if it's possible, since Mr. Gagarin, we can hear him in the house, we can see his car, and he's got this camera there, that, the next thing we're going to do is move for, notice by publication, which is a risk to him because he may not realize it's being published and he may not be able to get his day in court. My question for you is, since we have both of them here and Mr. Calamaro doesn't have authority, but his client is right here with him, if we could put him in a breakout room and see if they will acknowledge service on the next writ of Scalia Fascis that you enter for a court date, so that we can just get on with this and move forward.
So this is what I am hearing. Mr. Kaplan is saying that because Mr. Gagarin, his words, not mine, is actively avoiding service of process, he wants to seek a service by publication in this case. Mr. Calamaro? You're not required to make a statement, but I'm giving you the opportunity to do so.
Yeah, I mean, so a couple of things. I mean, I might point out that I don't even believe you can serve this petition by private process server. I'm fairly certain it has to be served by the sheriff.
We will.
Okay.
So, I mean,
I
you know,
don't-
we're getting a read on things, and I can tell you he's got a camera up. We'll have somebody testify whether they're qualified to serve or not. They're somebody that was there and observed that they went there one day and it wasn't there. Then the next time it was, that he has it, that he's in there, that his car's there. He's avoiding service. So whether a sheriff goes out the next time or not, and he hears a body inside and sees the car in the driveway, we're going to request the judge issue an order, and we can serve by publication when he's avoiding service. So we can do this, or we can do this for the next 5 years. It doesn't matter to me. It just seems silly.
Well, it's silly to you because you're representing somebody that says that they are owed
I
this
got
money.
it,
I
Mr.
don't believe
Stooksbury,
you.
but
Yeah.
hold on a second. This is
Yeah.
sort of pointed towards Mr. Gagarian at this point.
Yeah.
So at this
Well,
point,
I do not have authority to do it. I'll say
I got
that.
you. I got you, Mr. Calamaro. So at this point, Mr. Kaplan, if you will get me an order, you have my new staff attorney's email, Ms. Powell.
Yes, ma'am.
All right. So if you'll send Ms. Powell an order, then we'll go ahead and sign off on that. And whether you serve by publication or not is entirely up to you. I'll consider whatever orders I receive in this case. But now that we have smoothed the road, at least to having all parties present and heard, then, I will be here by video court if necessary the next time. Is there anything further at this time?
No, Judge.
No,
Okay.
Your Honor. Appreciate your time.
Thank you.
No problem.
And
All right.
I would like for contact information for Mr. Gagrin's attorney. I'm not sure that I'm going to even bother with this, but it would be worth.
I can put you all in a
okay.
breakout room. That's no problem. Mr. Calamaro, do you have an opposition to that?
No, I'm thinking my way through the potential for a conflict.
Yeah,
Yes,
that's
I
the
understand that. That's what I was going to discuss with you.
Okay.
So I don't know if he's seeking representation or if he's wanting to
Yeah,
talk
I
to you
don't
about.
know. I'd rather not have the conversation right now.
Okay.
Okay,
I'll speak to you off the record.
All right,
not a
then.
problem.
All right. Thank you.
All right, thank you all. And this hearing is concluded at this time, and I'll, sign and disseminate whatever order I receive.
Have a great day.
Thank you,
Thank you, Your
sir.
Honor.
Thank you.
All right,
you.
take care, gentlemen.
Take care, Mr. Calamaro.
Thank you. You too.
No.
All right.
Thank you.